Okay, thank you again for your continued patience. The solicitor will now explain where we are at this moment in time.
Yeah, so we appear to have everyone bar one representative, Dr. Johns. Mr. Phipps is partly a comment with you, really. With all of the other persons that we have been given this 50 minutes additional time for everyone to join, we were aware that they were in the lobby or they were actively trying to join. My understanding is that we haven't had any correspondence from Dr. John to say that they actively want to further, well, join to further, to further the representations. Mr. Phipps, Dr. John has provided quite a full representation. I think, with your leave, really, I propose that the matter continue, and then if Dr. John were to add on at during the hearing, then she be allowed to further her representations if she so wished. What is your view on that? Can you?
Yeah, I'm pretty relaxed as to whatever procedure you want to adopt, candidly. Some councils, 1 minute past 10, if you're not there, you're out. Others are much more accommodating. I'm certainly not here to try and exclude her. We don't know the circumstances. It may be shows not to attend, maybe that she's having some IT issues. If she turns up, that will be fine with us.
Yes, the officers are actively, I think they tried to telephone, there's no active telephone number, so they've sent an email. We have given 53 minutes now.
Yeah, I mean, obviously, and you will all know this, but not everybody who says initially that they're going to attend does attend.
Exactly. Okay, Chair.
Right, thank you. We'll now start the meeting. So item 1 on the agenda is apologies for absence.
No apologies, Chair.
2, disclosures of personal and prejudicial interests. No, there are none. 3 then, Licensing Act 2003, Section 17, application for the premises licence, Singleton Park, Mumbles Road, Swansea. The first bit, we'll go through the summary, we'll go through the procedures that the solicitor outlined at the beginning, and that's the officer will read the report, and then that's over to you then, Charles.
Thank you. The report relates to an application made to Swansea Council for a premises licence at Singleton Park, Mumbles Road. The applicant is Climax Promotions and Events Limited. It's for a new premises licence. The application was received by this authority on the 23rd of December 2021. The last date for representations was set as the 20th of January 2022. However, the application was withdrawn and resubmitted on the 17th of January with a last date for representations on the 15th of February 2022. It was agreed by the applicant that the representations that had already been submitted in relation to the initial application, they needed not to be resubmitted. The application is for a premises licence of no more than 14,999 capacity. This will be the total capacity of all persons on site. The application is for a maximum of 2 event days per year. The exact days and dates of events taking place to be agreed with the licensing authority, City and County of Swansea events team, South Wales Police and other members of the Safety Advisory Group. The application has applied for licensable activities listed at 3.4. The times of the licensable activities are 1100 hours to 2300 hours, except for late night refreshment, which doesn't start until 2300 hours and will end at 23:30. A copy of the application and plan is attached at Appendix A and A1. That's page 8 of this report and page 38. The premises subject to this application is Singleton Park, and the applicant has described the park as follows. Historical 250-acre grassland park situated to the west of Swansea city centre. The park is adjacent to Swansea University, Singleton Hospital, Sketty Hall and Bryn Mill Park. The park has been used for many years as an event space. The park's basic infrastructure includes metalled roadways, paths, running water and mains electricity to certain areas. The park has vehicular access via 4 main entrances and pedestrian access from several other gates around the boundary. The boundary is walled and or fenced. The emergency services have been in attendance at many of the previous events and are familiar with the traditional park event setup. Parking can be accommodated at the adjacent recreation ground and other local areas. As regards the location of the event within the park, the licence, if granted as applied for, would contain the following condition. A detailed plan of the final layout of the site shall be submitted to the licensing authority and safety advisory group no later than 7 days prior to commencement of the event, with the area within which amplified and organised music is to be played clearly delineated in red. The location of all structures and facilities, including roadways and event areas, shall be clearly indicated, and entry and exit points of all structures and areas shown. The locations of firefighting equipment, first aid points and information points shall also be shown, and the site plan to be gridded and referenced. Singleton Park lies in an area outside the commercial area of Swansea City and is surrounded on 2 sides by residential areas. To the east is Bryn Mill and Uplands, whilst to the north is Sketty and Glanmore. Events have been held at Singleton Park previously and have operated on different premises licence, one which is held by Swansea Council. The new application is totally independent from the existing licence. The existing licence allows up to 8 large events in any calendar year and has the following 2 conditions. No events which are of a large-scale concert type event with audience members over 5,000, where amplified music is the main component which goes on into the evening, shall take place on 3 consecutive weekends. And the second one is events which are of the large-scale concert type events with an audience members over 5,000, which go into the evening, where amplified music is the main component, shall be restricted to no more than 8 days per annum. That's the calendar year, 1st of January to the 31st of December. Any music other than the agreed ancillary music at these events will operate between 12 and 2300 hours. Ancillary music must be agreed in writing with the key stakeholders of SAG. Whilst Swansea Council have never held their total allocation of 8 events in 1 year, this application has the potential to increase the total number of large events held at the premises to 10 in any calendar year. Climax Productions and Events Limited, the applicants for this application, held an event in Singleton Park on the 25th of September 2021, which is referred to by the police and can be found on page 40, Appendix C. There is an error on paragraph 4.4. It does say that this was held on the existing Swansea Council licence, but Climax Productions obtained their own licence for this event. Promotion of the licensing objectives. The Licensing Act 2003 contains 4 licensing objectives, namely prevention of crime and disorder, public safety, prevention of public nuisance and protection of children from harm. Each of these objectives is of equal importance, and the application must demonstrate how they are to be promoted. Conditions consistent with the operating schedule and will be attached to the licence if granted as applied for are attached at Appendix D. That is page 69 to 76 of this report. Relevant representations were received from South Wales Police, Pollution Division, and other persons as listed at J of this paragraph. An approximate location of the homes of those who made representations and disclosed their addresses can be found at Appendix B. And I was subsequently asked for a map to show the location of relevant roads in relation to the representations, and that has been circulated as a Appendix B1. A full list of representations can be found on Appendix C. That's page 39. Members will note that there are several representations that make reference to the refusal of granting the licence on the basis of the damage caused to the park from a previous event and the likelihood of repeated damage caused by future large events. As members will be aware, this is not a relevant representation under the Licensing Act 2003 and should not be considered as such. However, as it appears to be a major cause of concern raised, contact had been made with Swansea Council's Special Events team, who have stated the following. Large outdoor events, despite detailed planning and our best efforts, will inevitably cause some damage when you factor in the weather. However, whilst mitigation against damage is put in place as part of the infrastructure requirements, the weather on the day cannot be predicted at the time that contracts are signed. As a result, reparation work and event organisers. Policy considerations. In considering the licence, this application, members should have regard to the current statement of licensing policy. A link to the policy has been provided. Guidance issued by the Home Secretary. Members should also have regard to the relevant parts of the current statutory guidance issued by the Home Secretary in April 2018. In particular, the Introduction Chapter 1, Licensing Objectives Chapter 2, Applications for Premises Licenses Chapter 8, Determining Applications Chapter 9, Conditions Attached to the Premises Licenses Chapter 10, Statement of Licensing Policy Chapter 14, and a link to the guidance is at the bottom of this chapter. Determination of the application. The decision must be based on the individual merits of the application and the representations received, with a view to promoting the licensing objectives outlined in paragraph 5 of this report. In arriving at the decision, members should have regards to the relevant provisions of the policy and the guidance as previously provided. Reasons must be provided for any departures from the policy or guidance. In reaching the decision, the committee must have regards as to the representations, take such steps mentioned below, if any, as it considers appropriate for the promotion of the licensing objectives, grant the licence, subject to conditions that reflect the operating schedule, modified to such an extent as the authority considers appropriate for promotion of the licensing objectives. Certain regulated entertainment under the Licensing Act 2003 as amended has been deregulated. Where entertainment is deregulated but licensable activities continue to take place on many premises, any licence conditions imposed on the grant of a licence in respect of the deregulated entertainment will be suspended. Any mandatory conditions relevant to the licence exclude any of the licensable activities to which the application relates, refuse to specify a person in the licence as the premises licence supervisor, reject the application. The licensing subcommittee's instructions are requested.
Thank you, Mr. Gay, for that. Are there any questions from members? No, Graham, Bridget? No, just like for clarification, It's mentioned in one paragraph event days, and on another paragraph it's days. So can you clarify for me that an event is 1 day? Because to me an event could be over 3 days. So if that could be clarified.
Yes, it's for 2 event days. These could be held over one weekend or could be held on different weekends, one at the beginning of the year and one at the middle.
Right. So just again, if it's a Friday and a Saturday, that's 2 events.
Yes. Yeah.
Okay. Yeah, the other one is 3.4 on the late night refreshment is just clarification for me, as it's from 11 o'clock in the night till 11:30.
Yes.
Can you explain that half hour?
Late night refreshment operates between 11 p.m. at night and 5 a.m. in the morning. No license is needed to sell hot food or hot drink between 5 a.m. and 11 p.m. and the license as such has applied for that half an hour between 11 p.m. when late night refreshment starts and 11:30 p.m.
Okay, thank you very much again. I've got no other questions.
Um,
Thank you.
Has got your hand up, but there's no questions now for officers at this point. As we went through the procedures, you'll have your chance later on. Okay, thank you. And Heather's got her hand up, and that's the same with you as well. Okay, thank you very much. Now we go on to the second bit, which is any responsible authority. So first of all, the police made representation. Do you wish to say anything at this point?
Officer Hancock.
Apologies, was that distraction? Can you repeat the question then? Sorry.
No, it's just that you made representation and just asked, do you want to say anything at this point?
No, other than the initial representation, no, nothing at this point. Thank you.
Okay, thank you very much. We've also had representation from pollution control, and the same is to them. Do you wish to make any comments at this point?
Hi. The only comment really to raise is that we've had discussion back and forth over email with the applicant with regard to whether or not there would be a link on a condition to the existing event whereby we would not exceed the 8 days per year, linking with this license application. So it was really just to raise that point on top of our initial objection. We haven't withdrawn an objection because we're unclear as to the position with licensing as to how 2 licenses would interact. But also just to sort of state that yes, from our perspective, if the total number of events in the park are held as they are now, as in to not exceed 8 days a year, then our concerns with the objection that we raised would be satisfied.
Okay, thank you. Any members got questions? No. Thank you. So we'll go on to the public representation now. I'll go through the list that I've got. The first one to speak will be John from Lathrid Avenue.
Okay. Are we ready to go?
Yes, off we go.
Okay, my concerns. It seems to me, listening to what's gone before, that this is going to be granted on the basis that it's within the 8 days. Okay. I have a question for the police. They are supporting the application, yet it's well known that police are undermanned. We can all see the results out in the Mayhill riots. They couldn't attend to that. I'm wondering, how will the police intend to man this event? Is it coming out of the promoter's pocket or is it coming out of council taxpayers? That's a question for the police.
Mr. Williams, this is your opportunity to develop what you've said in your written representations. There are some matters which are relevant to the 4 licensing objectives, and then some are not, and then there are other questions which can and can't be answered. matters relating to, well, unrelated instance shouldn't be factored into this application. This is an application which stands alone in its own merits, and perhaps this is a comment for all representations. In some ways, any application, this or future or past, shouldn't relate to outside matters or historic events. That said, ordinarily, I would say this is not an instance for cross-examination of persons, but if Mr. Hancock is aware of the answer with regard to the funding of inside-outside policing, he's welcome to answer it, other than, or perhaps he doesn't have to. It's a matter for him.
Well, let's forget about the funding of it and just ask a simple question. Will the police be manning up for this event? Will they monitor the streets to and from Singleton Park? Because in the past it hasn't happened in the streets.
Yeah, Chair, if I can just try and clarify a few points there. If I can give last year's example of the event in the park, it was police. There was a request for special police services, which was funded by the promoter. That was provided, so there were police resources inside and outside the event. Pending, obviously, the decision today in terms of the new premises licence, those discussions will take place with the promoter in relation to the policing inside and outside the event, as we do with any other events held within the park or the city as a whole.
Is that it?
Yeah, I'm not quite finished. The Special Events Department, as noted in the Vita. Well, first of all, a detailed plan of the final layout of the site should be submitted to the licensing authority and SAG no later than 7 days prior to the commencement of the event. I don't think 7 days is sufficient for the council to respond and for any necessary actions to be taken. That's just a point I'm making. With regards to bringing in the special events team comment about the state of the park, which I understand, and you've laboured on this, that it's not relevant to a licensing application, the destruction of the park, but it is the environment. I'd like Swansea Council to note in granting this licence that the environment is not being considered. I'd also like to mention that it's now 6 months since the last event by these people, and the damage in the park is still there. That's all I have to say.
Thank you, Mr. Williams. The next speaker I've got is Noel, about a mile from Singleton Park.
I'd say you're on mute.
Can you hear me now?
Yes, sir.
Well, good morning, Mr. Chairman. My name is Noel Edwards. I'm a chartered surveyor. My complaint is basically on two grounds: noise and security. At the recent conference or concert in Singleton Park of Catfish and the Bottomman, which I believe was the same promoter, the noise was unbearable. I could hear the noise. I'm a mile away from Singleton Park in Coed Van, and I could hear the noise above my television set. And it went on until late in the evening. I could even notice the group who were playing, encouraging the public to raise cheers and everything else. Now, if I can hear the noise a mile from Singleton Park, I sympathise for the people as in Parkville, Terrace and other parts of Sketty who live closer. Also, two-day events encourage organised groups of thieves. At the BBC Big Weekend, for instance, there were organised gangs of pickpockets. The BBC employed internal security who had no communication with one another. People were robbed on site and the police could do nothing about it and only learnt of the event of these things after it.
Mr. Edwards, Mr. Edwards, I certainly want everyone to have their opportunity to be able to say what they wish to do so. but each event is different. This applicant is standing on their own, and in some ways, for want of a better term, you probably
Well,
those matters, but no. Let me finish, because you've referred to matters which, politely I say, I've seen no evidence of. Do you know of any factual evidence regarding to the comment of the pickpocketing and things like that? Because
yes, my daughter was pickpocketed. She went to the BBC Big Weekend. There was no, when she tried to find internal security, they were totally disorganised. The police were not allowed to enter the park for that event. And that, in fact, was confirmed at a packed meeting in Sketty by representatives of the police who said they were outside. I can only, explain that was the position.
Okay.
But my main concern is that pop concerts obviously create a lot louder noise than other types of music. This I understand is for a pop concert. We already suffer 8 or possibly 8 weekends over the summer with loud noise, and this will add to the number of weekends and also to the volume of noise that we're going to experience. BBC Weekend was another event where I could hear noise inside my house. As I say, I shouldn't have to tolerate that living a mile from the park.
Thank you, Mr. Edwards. Is that it?
I think that rests my case. It's the number of events, the noise, which, can I just say about the Catfish concert, which I believe was the same promoter, that the volume went up after 9:30, and the last Swansea environmental reading of noise was 9:30 in Parkville Terrace, when it was at the maximum, and it went up after that. So, the responsibility of the people, either they're going to put in noise prevention measures, acoustic screens. You can buy it, you can hire an acoustic screening these days. This should be part of any license application if it goes forward. And I understand what the police are saying or support, but as I say, the BBC Big Weekend concert, they were outside the park, I agree, but they weren't inside the park. That was left to internal security. And it just brings 2 days consecutive, brings a lot of undesirable people into Swansea and into the park.
Right, thank you, Mr. Edwards.
Thank you very much, Mr. Chairman.
We'll take on board your comments.
Can I be excused, sir, now, because I'm sorry I'm looking like I do, but I'm just off site and I've got to go back to work.
Okay, thank you very much.
Can I be excused? Thank you very much.
Yes.
Bye-bye.
I could ask Dr. Sandy Jones if she arrived.
If I could shed light on that, I've just had an email from her now. She's experiencing technical difficulties and has been for several days. She's happy not to attend, to just be updated as to what the outcome is.
Yeah.
Okay, thank you for that.
Well, on that basis, perhaps I can say her comments that she's already provided, I think they stretch over 2 pages, are within the bundle, and of course the members will be directed to take them into consideration as a normal written representation would be.
Okay, thanks for that. We got Anne from Sketty now. I think Anne's with Heather.
Good morning. Can we first say we're terribly sorry for having held everybody up for so long, but we're pleased that we're finally with you. I have prepared, as a result of consultation with all the people that I'm representing, and I think the easiest thing is for me not to ask you questions, but just to read out a statement, if that's acceptable. Is that okay? Can everybody hear? Hello, can you hear me? Yes? Okay. We would like, first of all, to point out that we're not entirely comfortable, but realise we can't do anything about it, with the licence being determined in the normal way that licences are, by way of the fact that we feel there is a direct conflict of interest. If you wish me to elaborate on that later, I shall. We would also like to say thank you to the applicant, who we very lately received the information leaflet from, and we would like to make it plain that we are not generally questioning their ability to run such events. We are, however, seriously questioning the ability to do so at this particular venue, which is set in a residential area. Assuming its purpose to allay our fears, I have to say that it did not. Comparable events listed on the information we were sent, comparable in relation to type and numbers. Having looked at all those locations, they were significantly further away from residential areas than this one would be. However well meant, the even later undated and unsolicited letter was received by me at 4 p.m. on Friday, and we feel that this should not really be taken into account, as we have been given absolutely no opportunity because of the weekend to take advice on the content. And again, we feel that this could be a conflict of interest because of some of the content. Turning to the application that we received, we wish to draw attention to the incorrect information that the park has been used as an event space for many years. It has not. Sections of the historic urban listed park have been used, which, when they are, greatly restricts its use for the citizens of Swansea for the duration of those events, sometimes up to 7 continuous weeks, including the build-up, which is resulting in a loss of a valuable and well-used community amenity, especially for children and families in the summertime when they need it most. In relation to nuisance, if I may quote, the current statutory guidance for the 2003 Act refers, quote, authorities focusing on the effect of the licensable activities on persons living or working in the area. In addition, it also states the reduction of living and working amenity of those should be considered. And those of us who live in Sketty, Bryn or Uplands understand why those are mentioned. I've carefully analysed the content of all the letters of objection, and thank you for the way those were sent in good time. Public nuisance in its varying forms was cited in a staggering 93.3% of objections. Crime and disorder, 46.6%, and protection of children from harm and public safety jointly came in at 13.3%. As already stated, not directly being a licensing objective, it is important to note that 66% of objections raised the concerns you've already mentioned regarding damage, and 43% regarding the loss of the normal usage of the park, which can be an example of public nuisance by way of it being a protracted loss of amenity. Now, we fully accept there isn't an absolute definition of public nuisance. However, if this application were to be considered in a court situation, which could still happen, it's almost certain that the Common Law Commission's definition would be acceptable. And that is a common law offence involving environmental danger or loss of amenity or offensive public behaviour. We regularly experience all of those. Loss of enjoyment of one's home and garden is an offence in its own right, mostly in these cases due to the intrusive noise levels already mentioned over 12 continuous hours and 2 continuous days. That is almost all the time that most people are awake. The loss of amenity I've mentioned, the loss of the normally ordered quiet streets of residential areas because of offensive behaviour and foul language, both pre and especially post-event on performance days, sleep disturbance, public urination in streets, gardens, gateways and in the park itself. Even though toilets are in the park within the event, I can assure you they are not always used by everyone. Youth congregating in quiet streets does cause distress to elderly people. Now, all of those problems I've listed and more, many more, are contained in the bundle that you have, and they all constitute public nuisance. The addresses confirm it's not just by the park entrances, but also in the streets around and the main roadways to and from the event. And we would urge you to take account that 93% of these objections were on nuisance grounds. They surely can't be ignored. Can they realistically be avoided? With the event venue in a residential area, we do not believe that that is possible. The statutory guidance states, quote, premises with close proximity to residential properties should be considered in relation to noise management and dispersal policies. The advice from the Purple Book, which the applicant has mentioned in their application, if they were to not breach any statutory regulations or laws, advises that organisers, quote, consider the position and proximity of noise-sensitive buildings. Is it possible to satisfy both the requirements of the audience and the neighbours, unquote. At Singleton Park, we maintain that it simply cannot. There are at least 6 places of worship, 2 nursing homes, a hospital, many hundreds of residential dwellings, some literally within yards, but all within approximately a half-mile radius as sound travels from the venue. All of those and others have statutory recognition of being noise sensitive. The measures specified by the applicant to mitigate some of those problems already mentioned, we feel are totally inadequate to prevent or deal with the problems outside the event in our streets and outside our homes. Now, to be fair to the applicant, the only way to pace speakers away from noise-sensitive properties is to pace them all out to sea, which, because of the topography of the park, does not fit the purpose. And clearly, neither can the position of those properties be altered. To date, the statutory guidance and the Purple Book, we really feel that the advice contained there has been totally ignored. This application, in that respect, has also taken no account of the advice regarding the suitability of the venue. It is our submission that the existing licence is already causing our residents great and intolerable disruption through nuisance to their lives. To increase the number of licences, therefore increasing the ability to stage more such events, would be grossly unfair, who would suffer more of the same. We feel it would also be questionable. Whilst the council has not so far utilised all possible event days, if an opportunity presented, they could. It cannot be presumed that this will never happen. I have personally been inside escape events as well as outside, and I've witnessed at first-hand behaviour that would normally be an arrestable offence being ignored. The embarrassed senior police officer who I was with explained that to arrest would not only remove the perpetrator, but also an officer from the event, and he felt that would not be safe. Whilst I understood the concern, I realised then that the debrief figures of arrest did not reflect the reality of the nuisance experienced by residents, either within or without the park. We were not being well served. There are now even fewer police officers available. To date, the only section of the council ever to take into account the residents' concerns is pollution control, who on this occasion have registered an objection, which we fully support and are grateful for. Whilst Singleton Park is undoubtedly topographically desirable for such events, it is its position within a residential area renders it totally unsuitable. To quote again from the guidance, the legislation also supports other key aims and purposes which are vitally important. Please note the word vitally. One of those, quote, protecting the public and local residents from crime and antisocial behaviour and noise nuisance caused by irresponsible licensed premises. Granting this application, we feel, would again be the cause of our residents suffering exactly those things. There is nothing to prevent the council using its own licence as it did last time. An additional licence is not needed and would increase the number of possible events of this type permanently. This, we feel, would be of no benefit to the residents of the area or Swansea generally, as we are consistently told by special events that they make nothing by staging them. The only benefit of the promoters and the majority of attendees who are not normally from Swansea. It would not only be at the promoter's door that the blame would be laid, causing more suffering if it is granted. Regrettably, as both landowners and licensing authority, it would also be laid at the door of the City Council. We would stress that we are not against the council licensing such an event in a more suitable location, which is further away from residential properties and other noise-sensitive properties. The decisions made previously, we feel, have not been fairly balanced. To grant this licence will increase the imbalance to the detriment of our residents, and public tolerance really has been exhausted. We would respectfully and earnestly ask you to refuse this application in its entirety. Thank you.
Thank you very much for that, Anne. I don't know your surname, it's only down here as Anne from Sketty. Yeah, a very, very good representation. Thank you again.
Thank you.
Who we got now? Peter, Parkville Terrace.
Hi, my name's Peter Jones. I live adjacent to the park in Parkville Terrace, one of the aforementioned roads. My home is in front of the bowling green, and there are no buildings between myself and where this event happens. Now, I'm a disabled person, and getting out of my home is difficult for me. When these events come on, the noise, as previously mentioned, is unbearable. I would like to quote the repetitive beats law, that when events have happened outside in unprotected areas previously, that the police have been called in to stop such events happening, giving licenses to events which occur with massive repetitive beats, which, believe you me, are very, very loud. It was mentioned earlier that after 9 o'clock the volumes went up. I've experienced that. I live directly across the road. My house faces the park. The noise coming through, my TV turned up really loud. I can still hear those banging beats coming in. it is so distressing. The only way I can escape from this is to get somebody to come and collect me, to take me away from my home so that I can go miles away, and it has to be miles. I went to a friend's the other side of town in the Sandfields, and the noise was still effective there, which is over 2 miles away. So I am being directly affected by this. I'm noticing that even in the events, no offers of compensation or any facilities get offered to residents or the public in order to deal with this. Obviously, the business is just looking for money. They're just looking at how much they can make. They are not caring about the residents. They're not effectively contacted anyone and said these amenities would be available to you to help you through this. And as a disabled person, I am in a I'm in a position where these things affect me more than most. Other people can leave their homes, drive away. I have to get help to do that. And believe you me, these are becoming more and more uncommon, and more common rather. And it's affecting me year after year, 3 to 4 times, at least, if not 5, 6, every year. I'm being forced out of my home, or just grinning and bearing it, gritting my teeth. It's very, very upsetting. Apart further to this, when I've actually, after and during the events, I've had people coming down my street shouting, swearing when they mentioned urination in the streets. I saw somebody urinating in from outside the park into the park. There's a small park opposite Singleton Park, opposite my house. I got to the window, I called and said, please don't do that. The guy started shouting and swearing, came around, and actually started kicking the cars in front of my house, creating damage. My car was damaged. So I'm very, very unhappy with this entire situation. I know I'm not on my own. There's everybody in this street complains about it. You just haven't got them being represented here in this meeting at the moment. I say, being disabled, there should be reasonable adjustments made for people regarding this when there are events put on. No reasonable adjustments for the residents have been put in place whatsoever. Further to the location, there are so many locations they could put on events. You have stadiums, you have the rugby pitch down the front, which actually faces the sea. You know, you could be faced away from residential areas. They could find much more suitable, adequate locations in order to deal with these. But no, they want to do it in a park which is surrounded on most sides by residents and vulnerable people. The people affected, you know, a lot of young people I've been seeing kids, and I'm sure many of them are underage, who are going to these events, which obviously then brings into question the younger people being influenced and, you know, having negative effects on them. It brings a really unsavory type of person to the area. These are very nice, respectable areas, and the kind of people being brought in, as was mentioned, seem to come from out of town because they're looking for a big party. They want to go to some kind of rave or something, take all alcohol and drugs and behave however they want in and outside of the area, and that seems to be acceptable to the council. Now, I've suffered these now for several years, but more and more recently, the volumes seem to get louder at night. The repetitiveness of the beats seems to become something really unsavory. It was opera or something. The beats can be somewhat melodious, but these are just, it shakes the building. I'm in a building 500 yards from the park and I can feel the building moving. That's something completely wrong. I don't know whether they're having this sub bass on the floor, which is having the effect, but it's unbearable. I cannot stay in my own home. So what I have to do is find out every time these are happening and go and try and find friends or relatives, people who can help and to take me away from the area. I do not see how they've been granted licenses in the first place, but to extend these and make the public sufferance more seems totally ludicrous and totally unfair. At the end of the day, I really do feel they should make some adjustments. They should offer some reparation, not just for the damage they caused to the park, but the damage to people's quality of life and living, especially disabled people like me. You know, I would like to, yeah, it's just the fact of being forced from home. Yeah, volumes. Yeah, I think it's the unsuitability of the area, of the actual place is the big thing. It's the actual area is unenclosed. Now, if it was in a stadium, they have the sound is kept in. You can have 20,000 people, but the sound is kept in because of the way of the building. If it was in an arena, you'd have the same kind of thing. But in this area, you might get a 4 or 5 foot metal tin wall that stops no sound coming. So in that effect, the companies themselves are not putting adequate effects into place to stop the disturbance to the neighbours. They are not putting adequate enforcement with their own security to stop people being terrible on the streets and doing awful things. I say, as myself, I've been threatened. I do feel that personally, and not just myself, that a lot of people are getting affected very negatively and no help is being offered. It's my Swansea Council's responsibility to make sure that this kind of thing doesn't happen. I do not pay my rates in order to have the council allow people to put on events which publicly disturb people, especially disabled people like myself. I'm not going to hop on. You can see that it's very upsetting. Vandalism, crime, swearing, shouting in the streets, public nuisance, and the effect it has on the youngsters. All of this should be taken into consideration. I don't think there's any reason to further this license, and so I cannot accept it, this proposal. Please back me on this. I think we have enough. If there's already 8 licenses, why can they not use one of them rather than try and get even more disturbance to the public? Thank you very much for your time.
Yeah. Thank you, Mr. Jones. I'm sorry that you've witnessed all this. Obviously, we'll take all this into account when we deliberate. Okay, thanks.
Thank you.
Next. Oh, the last speakers I got is Councillor Nick Davis and Councillor Mary Sherwood. Are you both speaking? If you are, have you tossed a coin to see who's going first?
Yeah, Mary's going to go first.
Yeah, thank you, Chair. We have consulted on this before the meeting. Thanks. I am mindful that the environment has been mentioned a lot. That's something that we purposely didn't mention in our written submission.
Councillor Sherwood, you're very faint. We can only just hear you, and it's crackly.
I'll put my external microphone thing on. That might be better. Is that better?
There we are.
Much better, thank you.
Okay. So the environment has been mentioned a few times, and I realise that that's not provided for in the Licensing Act 2003. I have to say, I would imagine that at such a time that the Licensing Act gets revised to be brought in line with the Wellbeing of Future Generations Act, then damage to the environment certainly will become a licensing consideration. And in the meantime, the council is still bound by Section 6 of the Environment Act, which requires that in the normal course of carrying out our duties, we protect and enhance biodiversity. So in the course of our licensing functions, although protecting the environment itself may not be considered a relevant duty, the Environment Act would say it is. So I think that the committee should be aware of that. As to the concerns that we've written up in our own submission, most of them have already been alluded to by other people speaking today. Particularly, there's the problem of Singleton Park being right in the heart of a residential area. It's not a very big open space, and a lot of events of this nature would more commonly in other cities take place in much much bigger green spaces where the distance you would need to travel between where people are living and where people are enjoying the event is far greater than what we have in Singleton Park. I've been contacted, Councillor Davis and I have both been contacted on numerous occasions by people really in some state of distress, and where I've even been struggling to hear them on the phone as they've been upset by the noise. We've got crying toddlers, we've got distressed teenagers with exams the following day. It really does impact severely on the well-being of the neighbourhood, and particularly on children and young people, I would say. When my children were very young, I wouldn't walk with them down Wine Street at 11 o'clock on a Saturday night, right? I wouldn't do that. I wouldn't take them to a place where people were drunk and shouting, threatening each other, throwing things, smashing glass and peeing in the street. And yet this is what local residents have no option other than to tolerate, because it comes to where they are. They're not taking their children to this place. This place is arriving in front of their home, in front of their windows, and it's impossible to avoid. And as the last speaker, Peter Jones, mentioned, people want to get away from it, and people have different abilities to get away from it. So one mother that I spoke to just asked to have a schedule in good time of all the events so that she can plan her holidays and visits to friends and family around that. And it's good for her that she has transport and friends and family who are willing to accommodate her and a budget to be able to escape, because a lot of families really can't. We note the offer latterly received to work together with the council to make sure that the granting of this licence would not add to any more days of licensable activity throughout the calendar year. And Councillor Davis and I welcome that very much, with a sense of caution in that as yet we haven't had a year in which all the weekends that could be filled with licensable events have been filled with licensable events. And I can only imagine the distress calls that the council will be receiving from the public if that ever actually comes to pass. And the experiences that we've had in recent years have, I think, caused us to regret not having done more to bring down the number of events allowed under the council's premises licence, for all the reasons that we are discussing today. However, given that the council does retain that licence, and we're not here today to try and diminish that or discuss that in any way, the offer of the applicant on this occasion to reduce their days so that they wouldn't go beyond the days already provided for is very welcome. However, we're still very concerned at the suggestion that any such events could take place on a Sunday. During the course of our experience as local councillors, these have been the Sunday night events have been the ones people have been the most upset about and the most distressed about. Kids have got school, sometimes exams in the morning, parents have got work in the morning. It's just really unreasonable, and so we would ask that a condition is placed that Sunday is not in consideration, and also if the committee would consider, considering all the representations received today, consider the timing of the event, and that 11:30 is late to be discharging drunk and hyped up people out into our residential streets. And if the event could be made to finish earlier, if the event could be made to finish at 10:30, that's an hour less of drunkenness, isn't it? It's an hour less for people to consume alcohol before having to walk home past where we live. I myself, before I became a local councillor, I was aware of the reputation of Escape in the Park as one of the most hedonistic, boisterous and loud events that our city ever hosts. And on one occasion, I had to attend accident and emergency with a family member while Escape in the Park was on. This was before accident and emergency was moved to Morriston, so I'm talking about Singleton Hospital, where A&E was absolutely rammed with underage drinkers throwing up and needing to be looked after, and with injuries sustained as a result of drunkenness and of fighting. and alcohol fueled fighting. And it kind of makes me wonder why the health board isn't a statutory consultee for licensing, because the comments that I heard from staff on that occasion were, you know, they were despairing that the event is allowed to have, you know, drunk young people and underage drinking and violence.
Councillor Sherwood,
Yeah.
Of course you're aware every application is on its own merits, and this is an application, I'm sure Mr. Phipps would have said, new owners of the company, I think, but I think you're swaying away slightly from the parameters here when you're talking on the NHS and other such matters like that, and young persons without fully knowing where they had been to cause that injury or that consumption.
Okay.
I gently sway you to return you back. Apologies.
I take your point, Craig. The people in the hospital, the young people themselves, were quite open about where they had been, and the event was called Escape in the Park, which I think is the event that we're talking about licensing today. So, you know, if there are new applicants, new licensees, new people, that's all very reassuring. I can only reiterate that there is concern amongst the community from previous experience of such events, and indeed more recent events, as people have already mentioned, events that were not run by this particular licensed applicant, but they are of a similar nature and are likely to have a similar impact on the neighbourhood. Okay, so with that, I think I would just refer the committee to our written submission, which I think is quite comprehensive. And Councillor Davis and I would be grateful if the committee would consider not allowing any events on a Sunday and adjusting the timing of the events to be completed earlier when they ever do occur. I'm not sure if Councillor Davis has anything to add, but thank you very much for your time.
Right, thank you, Mary. Nick, last speaker.
Yeah. Thank you, Chair. Coming where I do in the list of speakers, you'll be reassured to know that I'm not going to repeat in detail all the points that have been so eloquently made, most notably by my colleague Mary Sherwood, but by other residents as well. And I'm going to simply try to summarise, I think, the concerns and capture the concerns expressed by my council colleague and by residents in as succinct a manner as possible. Number one, the lack of suitability of the venue. I think that the people who've objected to this event being held in the park, they're not NIMBYs. They're not regarding the park as just an extension of their back garden. It's an unsuitable venue because it's surrounded on three sides by housing. And I think Mr. Jones, one of the objectors, said, why not have it on the rec by the rugby ground, where at least it faces the sea. There's also the Liberty Stadium for these events. This is not the place to have this kind of event. I refer to the four licensing objectives, which do overlap to a certain extent, but my colleagues' reference to underage drinkers and possibly drug users being treated in Singleton Hospital, it is, in my view, under the purview of the licensing objective, which is protection of young people from harm or protection of children from harm. But I refer again in summary form to the incidents of crimes of violence, drunken disorderly, the possession and selling of controlled drugs, antisocial behaviour in its various forms, which I would say comes under the purview of crime, public nuisance, and crime and disorder in the licensing objectives. I refer to the numerous examples which have been cited by objectors, and I mean it's pointed out on the one hand that that's anecdotal and it's from a different application and a different event by different organisers, but how else are we to judge our response to an event which has not yet happened other than by referring to events that are similar in nature where these incidents have taken place? That's the only way we can, other than by seeing into the future, how we can make an informed judgment as to what kind of public nuisance these events result in. Regarding the number of days, I note the late concession, if you want to call it that, by the applicants, where they say that they will use one of the council's 8 days. That doesn't, for me, deal with the other issue of events on successive weekends, which is another limb of the council's own premises license for the park, which is in apparent conflict with this application if it were to be granted. I'd like that issue to be clarified. And then to conclude, I would ask that while opposing this application on behalf of residents of Uplands and Bryn Mill, which is the ward I represent, I would ask that if the licensing committee were minded to grant it, that it ends at 10 o'clock, that there is no event on a Sunday where people sometimes have to get up for work the next morning, they have to prepare for exams, they have to revise. So there's no event on a Sunday, that the termination is at 10 o'clock, not 11, and that there is no late night refreshment, which drags the whole event out until 11:30. So with those points in mind, I ask, I hope that on behalf of residents, on behalf of myself, that we've made clear our very, very grave objections and concerns about this application. Thank you.
And with that, can you take your hand down, Nick, please?
I'm doing so now. Yes.
Thank you very much. Right, we're on to the applicant. Yeah. Am I on?
No.
Yes.
Oh,
Yeah.
yeah.
Right, it's 12 o'clock. I intend now to take a 10-minute break, comfort break. So if you want to make a cup of tea or anything, we'll be back at 12:10. Okay, thank you very much.
Thank you.
Right, it's good afternoon now. Right, are we all back? Right, next on the agenda is the applicant then will make their application. So that's over to Climax Promotions, and who's speaking for you?
Mr. Phipps from me.
Sorry, I owe everyone a pound. It will be me, Sir Matthew Phipps. I'm the solicitor presenting the application.
Okay, Mr. Phipps, off you go.
So thank you very much. So first point, please, touched on by one of the residents, is just to understand the City and County of Swansea position. And just to flag it, I think it'd just be helpful from the outset. Obviously, you are the administrators and adjudicators of the application that's in front of you today, but you are also the premises license holder for Singleton Park, license SJ084081, what I've called the 8 license, the one that permits 8 large music events per year. And you are also the owner and therefore the landlord of Singleton Park, and effectively we have an agreement with you as our landlord to occupy the park. So I just thought it'd be helpful to flag. I'll be referring to our landlord as the relationship that we have with the City Council. And that's what I mean by landlord as I just do my presentation, which I hope is helpful. And when I refer to the 8 license, it's the pre-existing license that you as an authority already hold. I don't accept the point about there being a conflict. It's just one of the vagaries of the Licensing Act, but we just need to make sure we don't get confused on that. So the application is made in the name of Climax Promotions and Events, and they're supported by We Are the Fair and Full Fat Events. They are a leading and experienced expert, even, organizer of these sort of events. We've provided last week some materials that just introduce the capabilities, experience and expertise of those involved. I'm not planning to go through those in minute detail. I know the committee will have had a chance to have a look at those before we started today, but when you come to retire, I'd ask you to take those materials with you. To summarise them, Climax Promotions and Events have been promoting events for more than 10 years. They have significant events that they have organised in Newport, Cardiff and of course Swansea, because they put on an event last year, and they are now licensed to put on an event in Neath and Port Talbot this summer, a 3-day event there. And I'm grateful to Anne from Sketty to her observations that she's not here to challenge the experience and expertise of the applicant. Second slide just explains the context and how we came to be involved in this event, and there's been some reference to the historical position with Escape, so let me just help on that. That was an event that was held in what I'll call the early noughties, and I think was last held before last year in 2011. It was nothing to do with us at all, but in 2020 the City Council effectively asked us to become involved when there were some difficulties with the previous organizer. We stepped into the breach upon the invitation of the City Council and effectively honoured and refunded previously sold tickets, and then delivered the event last year. And we delivered that under the auspices of our own premises licence. Next slide touches on Full Fat Events, who have very significant experience and expertise across live music event organisation, as do We Are the Fair, and they are involved closely in the application process. They're organisers in their own right, and here when we come to talk about the event, they are the providers of the health and safety support for the event. So I'll run you through, if I may, the agenda papers. Appreciate Charles did that in some detail earlier, but there's some points to raise, and I'll do my best to give you the paragraph numbers as I go. So paragraph 3.6 is the description of Singleton Park. And a number of the representations, some of what was said to you today and others, talk about the occupation of the park, the loss of the amenity of the park and so forth. We will likely occupy 7.5% of the park. It's a 200, as you all know, it's a 250 acre park. And so I do ask you to bear that in mind when you are considering representations that talk about the loss of amenity, or indeed those that talk about this park being unsuitable in its entirety. Some parts of the park may well be unsuitable, but 7.5% occupation would fairly allow for the conclusion that equally some parts of the park may perfectly legitimately allow for events of this sort. At 4.4, the agenda suggests that the license last year was, the event last year was held under the City Council license. That was not right. We made an application for a standalone license, just as we are doing today, to be in our name for our activities, for our event, and that was granted. And for what it's worth, it was granted in circumstances where we had an almost identical dialogue and discussion with the environmental health team about the number of events, and we provided the same solution that I'll be turning to in due course last year, as we do this year, which is to ensure that the number is legitimately capped at 8. That then leads me on to the point that the councillor who summarised the representations is respectfully wrong to suggest that all the other events that are organised under the Swansea City Council licence help inform the representations, because there isn't any opportunity to make comment about us. That's incorrect. We had an event last year, and when you come to retire and look at the representations and everything that you've heard so far this morning, you will be undoubtedly struck by the fact there's hardly any comment about us at all. One doesn't want to be flippant, but it's almost a compliment to our event last year that the councillor didn't seem to know that we'd actually held an event under our own licence. So 6.4, there's reference to the damage in the park. And I know that it's been said by a number of people that they recognise that it's not a licensing objective, but let me just be very clear about that. We're fully committed to ensuring that the park is put into the correct state that it should be put into after we have been given the opportunity to occupy the space by our landlord. That is a specific contract clause. It stands apart from licensing, I grant you, but that does not mean that we don't take it seriously. And just important that I flag that. Paragraph 9.1 of the agenda, there's reference to each application being considered on its individual merits. And so what I say about that point is it is important to consider the individual operator, the nature, type and style of the individual proposition and offer, and the standards that they, not others, bring, and the conditions that they propose, which we say is critical. In terms of the licensing objectives, some talk about what's public nuisance and what's not, and what's relevant and what's not. What I say about that is that I'm afraid some intrusion or impact for events in a park, this park or candidly any other park around the country, there is bound to be some impact or some intrusion. I don't say that with any pleasure, that's just to be straight. Large scale event licensing around the country adversely impacts someone. That's not public nuisance, and you'll take advice from your legal advisor on that. What we are looking at today is balance, what is reasonable. It is not about managing out and away every conceivable risk. So the existing license, your license, if I can call it that, permits 8 activity days for large-scale music event licensing already. As we understand it, and very accessible on the internet, there are 4 events already pre-planned. I think our event will make it 5. Excuse me. A number of comments made by the residents and the councillors, forgive me, this morning, suggest that they have concerns about the operation of the historic premises licence, the council licence, and have concerns about, for example, noise levels at Cattlefish and anyway, forgive me, and the Bottleman Catfish and the Bottleman concert, with which we were not involved at all. That the representative who dropped off the call to go back to work seemed to suggest we were the same promoter. That's just wrong. But that is an entirely separate matter. That's a matter for dialogue. That might be, candidly, a matter for enforcement and even possible licence review, but of that licence held by that separate licence holder. In submitting our application, or prior to the submission of our application, we undertook pre-application consultation with the licensing authority and with South Wales Police. And there are and were amends to our application reflecting the feedback that we received, that in part at least may account for the lack of representation from the responsible authorities. And I do say the lack of representation from the responsible authorities is a matter of some significance when you come to deliberate. Some talk, particularly this morning, about the hours of operation. Our hours are precisely in line with the existing premises licence authorised to the authority by the authority. So we are not, if there was any doubt about it, we are not seeking to obtain anything more than that which has already been licensed for some years. In our event last year, we saw about 10,000 attendees. Vast majority of ticket buyers were from Swansea and Cardiff. It was, feedback to me has been a completely different event to what one might have experienced 10 plus years ago. And as I've touched on, it's not the same organiser nor the same promoter, but is a different audience to the historic escape events. And we believe and say unashamedly, the event was well attended and well managed. And that's feedback, candidly, that's been offered to us, both by our landlord and from officers. Now, that's not to say that there can't be improvements this year. These haven't necessarily been points that have been touched on this morning, but it's important that I flag there are, as there always is, room for improvement. So there will be some finesses to the event last year. We'll be having the entrance lanes finished and set up a little earlier. The security briefing to all of the SIA and stewards will be done earlier. We'll be reviewing our control log procedures. Our lighting towers will be fenced and protected. We will be deploying more lavatories across the whole of the site, and particularly at the front entrance. We're working with Curtis Lane from the council on our safeguarding and vulnerable people policies, and our hotline where people can ring in if they have concerns about the event or particularly about noise will be constantly manned by one person who will work that as their specific responsibility rather than it being transferred between people during the show. But that apart, it's not our view that anybody could fairly criticise last year's event at all. In support of this year's application, we've drafted an operating schedule, as I say, that has taken the feedback from pre-application consultation. There are 88 proposed licence conditions, which is more actually, not many more, but more nonetheless than the City Council licence. I don't propose to address them all, but I do wish to canter you through a number of the conditions and just the topic rather than reading out the whole word of the condition, which obviously you can do when you come to retire. So condition 1 is a maximum of 2 event days per year, but only 1 this year. And if committee see fit to condition it to only 1 this year, we entirely accept that. All events at condition 3 that take place under this license will be presented to and subject to scrutiny by the Safety Advisory Group. The plans will need to be disclosed at condition 4 no less than 56 days prior to the event. There was some reference to sign off of the final plan 7 days before. Just to be clear, all of the plans are exchanged with all of the officers significantly in advance of the event itself. We're merely there talking about a final agreed sign off. There will be an emergency liaison room to provide constant monitoring for the representatives of the licensing authority and emergency services who are present on site. There's some reference to, by one of the residents, to the police not being able to access the site at a different event, not ours. Candidly, I don't know whether that's right. It sounds wrong, I'm afraid, but that won't be the case at our event. There will definitely be police engaged, and we are and have continued to have an excellent open, cooperative, collaborative relationship with the officer. And candidly, you don't need to take my word for it. You merely need to ask John Hancock, who obviously is on this call. 19, a reputable and experienced SIA security and stewarding company. 29, no glass bottles. 30, a challenge 25 policy. 32, no one bringing alcohol onto site. 33, frequent waste collections and disposals. 37, searching. 48 talks about the event safety management plan being developed in line with best practice, such as the Purple Guide, which one of the representatives referenced this morning, which is obviously specifically touched on in your licensing policy as well. Queuing system at 51, suitable sanitation at 61. Safety advisory group to be invited to carry out an inspection on site at 67. No amplified music after 11 p.m. at 76. Significantly, an experienced and suitably qualified noise management consultant to be engaged to liaise with environmental health to develop and implement the noise management plan, which will control and supervise noise. And a number of the representatives made points about making sure that the setup of the various systems was suitable and mitigating and not likely to cause a nuisance, and we entirely accept all of those points, as, to be frank, would the environmental health officers. I can't say what other organisers have done, or candidly what they haven't done, but we have a plan, we have a proper consultant, and we have a proper engaged relationship with the suitable officers. At 80, residents to receive prior notification of each event. It was a point made by a councillor about having a good lead-in period to make sure that everybody understands when and where our events take place. Entirely accept that. It's a good point. And you will have seen from the letter that we circulated at the end of last week, we've proposed to continue that dialogue. And one of the responses that we've had on that effectively welcomed that dialogue. Fair to say they were maintaining their objection, but nonetheless, they welcomed the dialogue if the license were granted. Noise hotline number, that's at 81. 82, all calls to the hotline to be logged and recorded. 83, adequate litter collection and disposal procedures. 84, post-event cleanup will be agreed with the parks team in advance of the event. And 88, suitable signage. The point about the operating schedule, which we say, and of course you'd expect us to say, but we say, and it's reasonable to conclude all the responsible authorities agree as well, and arguably all the residents agree as well, is if you're going to grant this application, and I grant you that's an if, but if you are going to grant the application, then that is a legitimate and proportionate operating schedule balanced against the activities that does the correct job of governing and controlling this proposal. And at the heart of those conditions, a condition 5, which I haven't flagged, but is important that I flag now, is the event safety management plan. The event safety management plan is the basis by which most, if not all, large-scale event licensees organise and manage their affairs. It's effectively the collection point for all of the policies. And if you look through the conditions, again, when you retire, I needn't take it through it now, but there's reference to the traffic management plan, the prohibited item policy, the major incident plan, waste management, noise management, egress, fire risk, medical, wind management, adverse weather plan, lighting plan, lost children policy, and everything that you would expect. All of the risk assessments, policies and procedures that go into delivering a successful event. What I say unashamedly about that list, which is in the application from the outset, so we are obliged on pain of prosecution ultimately, and or licensing review to deliver to that, is it fairly discloses a significant level of competence and expertise, so that you know that you have the right applicant, the right organizer for these events. But of course, you needn't really take my word for that, because you could turn quite quickly to the police representation, and the police do not serve, unusually, a representation seeking additional conditions, or indeed in some cases seeking to get the application refused. What they essentially say is that the dialogue with the applicants is good. That will be continuing up to the event and through the course of the event itself. And in those circumstances, there's not really a necessity for them to say more than that. We obviously welcome their officer's engagement. He's on the call. You can hear from him. But you will be struck undoubtedly by the fact you don't always get positive representations from the police to events of this sort. It's very much in my client's favour that he does have that sort of observation here. You'll have heard, of course, some criticism of the police earlier in the course of the morning about their not being able to access site for a different event. I've made the point that I think that that's just wrong. But that may be a point that you will want to speak to John on in due course. We've then got the environmental health representation, and that is directed toward the 8-event limit. You can read the representation for yourself, and obviously we heard from Mr. Price earlier, but it's clear that it's all about that. We have proposed an absolute solution to that problem, and it's an absolute solution, of course, with precedent, because that's what we did last year. The wording slightly different. The wording has been tidied up and probably improved from last year. But what we say is a condition on our license needs to say the activity day or days authorised under this permission will only be so authorised when the licence holder, yourselves as City Council, confirm they'll forego a day or days so as to ensure the maximum number of music events held in this park is no more than 8 in one calendar year. It is a perfect, if I may say so, solution. And as the officers have said this morning, if the total number of events is honoured, then they'll be satisfied, and they accept that their conditions are all met. Just a point about enforceability and it being honoured. The existing licence holder is Swansea City Council. I don't think anybody is suggesting that they would entertain a sort of scheme of thing to try and put more events on than 8, but you know, I don't know what I can say to you more than, do you trust your own officers? It is a clearly enforceable condition as it attaches to our license. Either we produce a letter, a written confirmation we're allowed to put the event on, or we don't. And if we don't, well, it's our lookout. It's a risk. That's commercial risk. It's what we deal with every single day. But of course, that's not the end of the controls here. We need to have written confirmation of an agreement from the council as license holder. We need to have written confirmation and a contract to agree to allow us to lease the space from the council as landlord. We need to have meetings, dialogue, and effectively sign off with the safety advisory group, i.e. all the council officers, as well as other stakeholders for the event. And that includes a condition to the date and time sign off for the activities themselves. And that's again with city council officers. And it's an ongoing application and an ongoing license. So you as enforcement authority, again, council, have both compliance and enforcement powers, including closure powers, at your disposal. So candidly, I can't see any circumstances in which it isn't a perfect answer to what is undoubtedly the primary concern when one looks at all the representations. Now, that said, residents raise a number of other concerns. Important that I attend to those. I'm not planning on going back through the increase in the number of events, or that there are too many events at the location, because candidly I say the condition addresses that. In terms of excessive noise, I've touched on that. I can't comment on this Catfish and the Bottleman concert, or indeed other concerts, but I can say that nobody, so far as I can see, is suggesting that our event breached its license conditions, which are specific and were effectively agreed with environmental health and mirror the existing license. The telephone hotline needs improving, and we accept that, and I've touched on condition 81, and we're going to have one person focused on that, with all calls being logged. Entirely accept that. There's some concerns about litter and rubbish. We've proposed conditions on that, and we've also got effectively a overarching condition that we have to have agreed that with the parks team in advance of the event. So that again is all conditioned. There's some reference to disturbance to sleep, and some concerns about younger children being disturbed by the event. We are entirely respectful of the points that are made, but we are not in a position, nor is any licensee, to manage out any conceivable impact at all, I'm afraid. We are one day a year, and we don't say that the fact that some people will be adversely impacted is a fair basis on which to refuse the application. Then a number of the representations touch on crime and disorder, and I think we had the percentages from the lady who spoke earlier. What we say in simple terms about crime and disorder is hear from the police. That's a point that's made in the national guidance, which I'll return to in due course. The police have absolute transparent access to all of the materials, and indeed all of the people at the applicant side. You can see the extent of the operating schedule. They effectively have sign off. They are represented in all of the discussions and all of the dialogue. And whilst there are some concerns quite properly articulated, can you look through our application and see that we are doing everything that we can, straining every sinew, if you will, to attend to all of the concerns that are identified? Then I say you can. There's a spread of COVID-19 point raised as a public safety concern. It's not my view that that is a legitimate veto. And again, you'll take advice from your legal officer. But certainly through the course of last year, we were working hard to ensure that we managed our affairs sensitive to the global pandemic that everyone faces. And it's not our view, respectfully, that that's a legitimate basis on which to refuse. And then there are points in terms of the protection of children from harm. Dangerous exposure to litter and waste is touched on in one of the representations. Well, we touched on litter and waste already. Some reference in passing to underage drinking. That was not our experience at our event at all. We are strict on that. And I've touched on the Challenge 25 policy, and we have a wristband policy for those for attendees and so forth. There are, as well, it's fair to say, a number of points that are respectfully not relevant to the licensing objectives. I'm not planning on going through those in detail, and your legal advisor will touch on those. But for example, alarm at seeing intoxicated people, the damage to the condition of the park point, damage to house prices, that sort of thing, I'm afraid, and without wanting to be too legalistic, doesn't seem to be legitimate. There's also some reference to adverse effect on those studying for exams. This event is proposed for the 20th of August. Let's just be very clear about that. So insofar as this application is concerned, at that point, if it was deemed to be relevant, which I don't think it could be, but even if it was, that would be wrong for this year in any event. It's right that I just touch on a couple of other points made by residents this morning, sort of criticising the police for their lack of engagement at an event, and criticism of environmental health monitoring of concerts, and criticism of the BBC event that is the one that is said to have pickpockets and a clear crime problem. None of those are us. I respectfully rather doubt whether the criticism of the officers is legitimate, but they are here and it's not for me to attempt to act on their behalf. But I do know that it is not this promoter, this organizer, or anything to do with us. Another point to make is that from the materials that you heard this morning from the representatives, it is fair, I hope, for me to observe that a number of points were raised this morning that were not in the written representations that the individuals were speaking to, which is improper. But I do get the point that was very fairly made by your legal officer that interruption was not to be countenanced today. And so I didn't want to interrupt anybody who was bringing up new matters. But there were some matters that could fairly be said to be new, not contained in the written representations, and shouldn't form part of your deliberation. The repetitive beats law, which I'm bound to say I'm not familiar with, but nonetheless that does not appear in the representation. Nor could we, for example, nor would it be proper, be legitimately offering compensation to those who say that they are adversely impacted. That would candidly look, sound and smell completely wrong. As far as I could see, nobody actually talked to last year's event. And I say that that is a point of some significance. There was some reference to the future environmental protection legislation that may impact the future redrafting of the Licensing Act. I hope I'm pushing at an open door when that couldn't really be a legitimate consideration for today, even if it had been brought up in the original written representations, which it wasn't. The schedule of events point is a good point, though. Could and should we be providing proper advance notice of the days on which our event or events take place? Yes, and if condition was to be finessed or amended to ensure that we provide a good and comprehensive time frame for residents to know when we are putting on activities, I don't think that there's any objection to that at all. And then one other representative expressed surprise that public health are not a statutory consultee to a licensing application. Of course they are. They are a statutory consultee. They've chosen not to serve a representation, which by its very nature we say has some significance. Just turn to the issue, a couple more issues before I finish, and thank you for affording me the time. Just talk a little bit about risk. We're not able to eradicate every last possible risk. Licensing is about proportionality and balance. And nor, candidly, are the residents or councillors in a position to say that all of the anxieties and concerns that they have will materialise. Candidly, if we were to eradicate every last possible risk, then there's an argument for saying you'd have to close all licensed premises up and down the country, just as you'd have to close all motorways, and it would go on and on. Risk is a balance. It's a matter to be managed as best we are able. Looking at the applicant, looking at the conditions, looking at last year's event, our event that we organised, we say that the risk here has been fairly managed, just as the risk with the non-delivery of the letter from the City Council, which wouldn't allow our event to go ahead in terms of the limit of 8. So there is no attempt by me to pretend that I can offer a cast iron guarantee that something may or may not happen. If that were the case, no licenses would ever be granted. That's why you have enforcement, that's why you have reviews, and that's why you have licensing committee decision making. Turning to your licensing policy, please. Again, I will rattle through it, but for your legal officer's benefit, I will give you the paragraph numbers that I say are material. So page 5 of your licensing policy talks about the Licensing Act introducing a range of opportunities, and among these is the ability to have a wider input into the development of leisure activities. The entertainment industry within the area is a major contributor to the local economy by attracting tourists and visitors, helping to keep areas and communities vibrant, and providing major employment opportunities. Paragraph 8.2, licensing authority will consider the individual merits of each application. 9.1, council will ensure a comprehensive licensing policy is maintained having regard to other policy strategies and initiatives operated by the authority. 9.4, licensing authority will have regard to the need to encourage and promote live music, dancing and theatre for the benefit of communities generally. 9.5, the council, when acting as a licensing authority, will liaise with the police and highway authority to ensure as far as possible transport arrangements that promote the council's licensing objectives. 9.6, the council, when acting as a licensing authority, will have regard to the needs of the local tourist economy and the employment situation for the area as appropriate. 12.3, licensing authority will attach conditions to licenses or certificates that are tailored to the individual size, style, characteristics and activities taking place at the premises. 14.3, organisers of outdoor events are encouraged to refer to the Purple Guide, which of course we specifically have done within our operating schedule. And 18.2, applicant for a premises licence will be expected to conduct a thorough risk assessment with regard to the licensing objectives. And you will see that the event safety management plan is that in significant detail and significant part. In terms of the national guidance, I would ask your legal officer to have some consideration to paragraph 9.12, where each responsible authority, it reads, will be an expert in their respective field. And in some cases, it is likely that a particular responsible authority will be the licensing authority's main source of advice in relation to a particular licensing objective. For example, the police have a key role in managing the nighttime economy and should have good working relationships with those operating in their local area. The police should usually therefore be the licensing authority's main source of advice on matters relating to the promotion of the crime and disorder objective. So in those circumstances where there is essentially no objection from the responsible authorities and where there is very little in the way that could fairly be said to be attributed, if anything, to ourselves, our organisation, our experience, our abilities, or last year's event, I invite you to grant the application, confident in the knowledge that we are the right organiser for this event in the right space. Thank you very much.
Yeah, thank you, Mr. Phipps. Before we move on, I'll ask Craig to come in.
Yes, good afternoon, Mr. Phipps. I raised the hand partway through. I apologise. I was raising it in relation to the proposed condition you put forward, but in some ways, as I raised it, you continued on to refer to the contractual points which you have as the next stages. Hypothetically, if you were granted a licence as per the condition, as you've already raised, you would have to seek authority, if you like, from the landlord and other people to allow you the usage of the land. I say it like my comment like that because, as you've heard me already in this committee, I've commented that every license, every license should be made on its individual merits. And in fact, I think even you said it when you gave direction to myself as the legal officer. Now, I pass a comment in relation to the proposal. It effectively, as you set out, the activity day or days authorised under this permission will only be authorised when the licence holder, and refer to the 8-day licence, confirms that they will forego days to ensure that the maximum number of music events in the park are no more than 8 in one calendar year. Now, I have concerns that if your application were granted on that basis, it would be tied to another licence, and therefore would it be on its own merits? My view is that a licence should be precise. Well, I could perhaps say that what you put there is precise, but is it enforceable? Because technically, if that other license were to be amended in some way, then would that then have a knock-on effect on what you're asking for? And therefore, could there be a question of whether it's enforceable? I've scratched my head while we've been looking at, and I've been looking at the 182 guidance, and of course the license is to be tailored to individual type, the location and the characteristic. It must be proportionate, justifiable, and capable of being met. And as I said, the point, if the license you're tying yourself to is varied or whatever, up or down, who knows, then could your license be met? And
do you mind if I just answer that as a question? I appreciate the point that's being made, but when we were talking about risk and commercial risk, we can't manage out every conceivable issue.
I know
we can't manage out. Sorry, just a moment. We can't, for example, COVID. None of us had ever heard of that, or I certainly hadn't, 2 odd years ago. And the whole of the events industry, as an example, basically disappeared in 2020. If the premises license that you're concerned about, which is candidly your license, let's not forget, were changed so as to frustrate us receiving this letter, that's our lookout. That doesn't in any way, respectfully, just to finish the point, it doesn't go to the licensing objectives. It feels, if I may say so, we're trying to manage out every conceivable risk, something that could happen, might happen, but hasn't ever yet happened. That's not the purpose of today. What we've identified a primary concern for officers and residents and provided respectfully a perfect solution to it. I don't see that there's more to say than that.
Mr. Phipps, I completely see your point. We know that there was an issue to be dealt with, and your proposal deals with it in some aspects, and that's a matter for the members for consideration later. The point I was going to get to, before you corrected me or added what you wish to say, is that, again, the 182 guidance sets out that a license should not be overly burdensome. I have concern that tying it to another license could be burdensome. However, looking at it, it's tying there, but perhaps I'm sure we're going to break for lunch at some point. I just query whether or not you would consider any alternative wording, really, in a sense, and then that's a hypothetical, because at the moment, unless, well, do you follow what I'm saying in relation to it should stand on its own and it shouldn't be burdensome on another license?
I don't, Candid. Sorry to be blunt, and we're not here to be rude. No, I don't. And burdensome in the way in which the national guidance is written is, to my mind, all about being directed toward councillors and officers, or when I say councillors, I mean committees, not seeking to impose unnecessary conditions or inappropriate, as we now use the phrase, conditions on licensees. I'm proposing this condition.
Yes.
The burden is not being imposed. I'm saying I can carry this load. If I say I can carry this load, I can carry this load. That's completely different to somebody else. Sorry, John is top of my screen, so I'll pick on the police. That's completely different to the officer serving a representation saying, I insist you carry this load. That is not the same thing at all. If I say that I will take the risk, then it's perfectly legitimately imposed. As to a different wording, well, of course I'm open to that. If the view of the committee or indeed the legal team is that the wording isn't as precise as it needs to be, or it could be improved in some way, I'm not adverse to that. But the point is a simple point. Almost all of the residents and the EHO don't currently want more than 8 events. We are trying to be helpful here. We are not trying to be anything other than helpful. And we are trying to find a solution to the primary focus of the objection. And I might add, which is what we did last year. Nobody suggested we did anything wrong last year when we did just this. We submitted an application There was dialogue about an increase in events, and we explained that we had confirmation from you, candidly, that the council would forego one of their days on their license last year. Nobody said it was a problem last year, and it wasn't a problem.
Yeah.
I think it was said earlier that the council's never actually used all 8 days.
We're slightly moving away from the point
Okay.
I'm trying to pin down, but for me, and you're putting forward this condition, are you aware of any precedent or case law where you can attach a new license to an old? Because I'm scratching my head.
We're not doing that. We're not doing that. There's no attachment to the license. Respectfully, the confusion is about the city and county of Swansea. Sorry, I can see Miss Evans has got a hand up, but if I'll just finish the point, please. Yeah. It's not attached to the other license. The confusion arises from the premises license holder for, forgive me, I'll give you the license number for license number SJ084081 is the city and county of Swansea. The correspondence that we need to allow us to proceed is from the city and county of Swansea. They're also our landlord.
Yes.
It's nothing to do with their license. It's they're being the license holder.
Exactly, and this is my point. In that, by no means, do I know what the outcome will be here, but I can see a potential issue further down the line. So therefore, if you were to remove the license holder to the landlord, because in your contractual point you would have to seek the confirmation from the landlord you're allowed to use that, then would that not deal with what I'm foreseeing? Yes,
I mean, look, if your view is that it's better worded in that way, then we're not going to be arguing with you. You forgive this phrase, but we're slightly dancing on the head of a pin because it's going to be the same person in the same department at the same local authority that is writing this letter, whether they're writing it as license holder or landlord or license holder / landlord. The point that's important for the residents, the point we've done our best to find a solution for, is that there's no more than 8 events and that this doesn't offer the opportunity for more. And that seems to me is the point. The terminology of who writes the letter, respectfully, doesn't. We're not going to argue with you about that.
I completely get your point, and in respect to what you say, but for me, I'm looking at the legality of this, and to me, hypothetically, if that were granted, it matters. But I think we're on the same page now with regards to any possible amendments.
Yeah, to take. Sorry for talking over you. Let me take the point simply for the benefit of the record. We're not going to fall out over the wording. It's the wording. Obviously, it's you issue the license. You want to be satisfied with the condition wording. I'm not sure I'm here to haggle the wording. Respectfully, I think our wording's right. But if you tell me you disagree, well, there we are. That's a matter for you guys.
I was just it's a matter for yourself. I just wanted to raise this openly so that all parties were aware. Apologies to raise it with everyone, but there it is. I'll move to the side now, because of course the members should have first had the opportunity to speak to the applicant and or ask any questions if they so wished. Miss Evans, as I said, it is for the members to speak now. There will be questions post the members. Ma'am, so Miss Evans, sorry, I say Miss Evans, Miss Davis, perhaps this isn't the opportunity for you right now.
Right. Thank you for that, Mr. Fifth and Craig. Craig, any questions from members?
I got no questions, Chair.
No, Bridget. Okay.
I just wondered if could I just ask a couple of things, if that's all right?
Yes, off you go. To Mr. Phipps now.
Yes, please, if I could.
I don't know why I'm cutting out.
Just clarification, really, for my ignorance. I think I'm sorry if it's not
I'm cutting out all the time.
Clear. Can you hear me?
I can also hear Mr. Jones at the same time.
Okay, so just clarification on a few points that I've picked up. So during an event, can the public access Singleton Park?
Yes, our occupation of the park covers about 7.5% of the park.
So the public still have access to Singleton Park during an event, yeah?
Yeah.
Okay, thank you.
Can I just add, and forgive me for this?
Yeah.
I don't want to make that comment about the other events that are organised under the auspices of the City Council licence. Obviously, that would be a question for them.
Yeah.
But for the purposes of our event under this application, yes.
Okay, and can you just confirm which event you held last year?
Yes, it was the same event. It was the escape event last year, September
Fine.
of 2021.
Yeah, okay. Sorry, I'm just reading these as I've written them. And if granted, how long will this licence last?
It's a licence, like all premise licence applications, really in perpetuity. Last year's was a 1-year licence. I don't want to call it a trial, but last year was the trial, and this year is a permanent licence.
Is a permanent one. That's all I needed to ask. Thank you very much.
Thanks, Councillor.
Thank you, Bridget. I'm asking from councillors. It's my intention to break around 1:15 for lunch. The next topic is questions from anybody to anybody. Can I just point out that these are questions, you will get an answer, and that's it. It's not a dialogue between two people. So if you've got a question, you put it, and we don't go on about what we have before. So if I do stop you, if you're going on about making statements other than questions, don't hold that against me. Right, first I got is Anne.
Hello?
Anne, you're on mute. Is
Just cutting out all it.
Yes.
Can you hear me?
Yes.
Yes, thank you. I am also a little concerned, as I had asked. I don't know whether Mr. Gave got my communication, because obviously, having received the information that in the form of the letter, I don't know if he got my communication. I was asking that the whole of that was disregarded because no one has had the opportunity to take legal advice regarding the content of it. Now, our main concerns regarding gifting a day is the fact that the existing licence, the council's own licence, the licence itself is for 8 events, clearly 8 events. I do not know if it is legally possible, because as far as I'm aware, it's not been done before, whether you can gift part of a condition, because the only way that days are referred to in the licence is as part of that condition. Is it legally possible to be part of a condition, not an event? And if it is, who bears responsibility if there are lots of problems? Is it a shared responsibility between the 2 licence holders, or would it just be one or the other? I think that, as far as I'm concerned, that is a grey area for many people at the moment. We really need to look into that thoroughly, know the answers before we can make them come to informed judgment. But I think it would be absolutely crazy to grant something without having had the time and the opportunity to go into all the possibilities of doing that. And we are very gravely concerned about that.
May I answer that?
I think it's a question, an answer for both Mr. Phipps and myself. No, Mr. Phipps, I was also thinking which one of us is going to deal with that. I think my part is the first element, Ms. Davis, where you have, I understand, sent in an email, I've had sight of it, where you wish the members to disregard the letter sent on Friday. Well, I think you've based your view in relation to documents or other evidence, which would come under the caveat of the time period you're saying. I don't agree that this document is other evidence, and I'm not speaking for Mr. Phipps, but I think this is an acknowledgement or notification to representatives or putting them on notice that the applicant intended to do this. I think Mr. Phipps can lead on from there, but I don't think your point with regards to disregarding is valid, because I don't think it falls under the auspices of what you're saying as it is. To me, it reads as a notification as courtesy.
No, hang on, Mr. Phipps, you've asked your question.
So yes, thank you. So a couple of points. First of all, it's clearly a document that's produced in advance of the hearing, so there isn't any discretion. Unfortunately, it's produced on Friday, and that's for me to apologise for, because you'd always like documents and materials to be produced with a longer lead in time, and I entirely accept that Friday afternoon is not ideal for a Monday hearing, and for that I apologise. I hope you will understand that between the dialogue that went on between our landlord, yourselves, your environmental health officer colleagues, and licensing, and the fact that all of the contact details for the individual residents is redacted and not available to us, so we had to serve the letters through your licensing colleagues, that may have accounted for some of the delay. But if it's a general observation about my needing to apologise for late arrival of it, I accept that. Can it be excluded? No. But actually, candidly, the letter's a bit irrelevant. The point of the letter was to not blindside anyone with our proposal for a solution to the primary concern. We believed we were being courteous. I appreciate it seems to have been taken by the resident as in some way improper, but we were trying to be courteous to let people know before what we were going to say on Monday. In terms of the interaction with the other licence, Miss Evans, I don't accept respectfully any of the points you make. There's absolutely nothing wrong with this. There is a risk, but the risk is only borne by the licence holder applicant. There is nothing that could possibly be said to adversely impact the licensing objectives of the attachment of this condition. And if it's being suggested that in some way the City and County of Swansea would conspire with my clients to fix events to exceed the number 9, then respectfully, and there is no respectful way to say this, then that perhaps is the point at which we completely depart and the committee will be asked to make their own decision, because I simply don't accept that that's got any basis in reality at all, I'm afraid.
Yeah, thank you. No, hang on, you've had a question, you've had an answer. If you have another question, then I'll come back to you. So, Peter Jones. Yeah. Peter. You're on mute.
Sorry. Hi. I have a question to the solicitor. Basically, he said it was regarding the compensation of residents, etc., and especially myself being a disabled resident. You said that it would be ridiculous to pay compensation, or made that assumption. But under the Equality Act, reasonable adjustments must be offered to those who have a disability, particularly people like myself. And so if you do not make reasonable adjustments, you are in effect breaking the law. You have not taken this into account. So reasonable adjustments should require that, given this kind of situation, that you should see disabled people and take appropriate action in order to allow these people to live decently. If you do not, you're breaking the Equality Act. So I'd just like to bring that forward.
So I hear that point. The point I was trying to make.
Yeah, it also breaks the Human Rights Act. So, you know, this is not being taken into effect. You've not offered any solution to that. You just dismissed it. Please clarify what you intend to do.
Yeah, so my point I was trying to make, and if I made it inarticulately, then I apologise, is that licensees offering residents who claim adverse impact to
I've seen it done.
licensable activity events to make offers of compensation is not candidly how licensing works, and one could very quickly see that that would be seen as wholly inappropriate to my mind. And I was saying no more than that. I was not making any observation about the equality legislation at all, and I was not wanting to suggest that we wouldn't be fully observant of that.
If I can interject.
No, you can't come back. Mr. Jones, you've asked a question and you've had an answer. I don't know, Heather, Anne, you've still got your hand up. Have you got another question?
Yes, Miss Davis.
Miss Davis, is it?
Thank you for that. Yes, it is Mrs. Davis, Mrs. Peregrine Davis, but I don't mind what I'm called. Probably lots of things. I have a question in relation to what was said, that I feel it is impossible to ensure that if an additional license is granted, how can you possibly say that the number of events won't increase? You cannot guarantee that if an additional license is granted. You cannot guarantee that the residents will suffer no more than 8 of these type of events a year. I fail to see how that is possible. Can you explain to me how you can do that?
Yes, happily. We have proposed that a condition is attached to the license that we will need to produce, otherwise our event will not go ahead. That's in addition to all of the dialogue we had earlier about the landlord needing to lease us the space, the safety advisory group signing off on the application, all of the licensing officers agreeing the time and place of the activities. The conditions of the license are, in simple terms, a legal obligation that we must deliver to. Absent a legal obligation, then, you know, if it was just in the air that we promise we wouldn't, well, that would be one thing. But we have got to produce this. And I do say that it is simply not reality to think for 1 second that the City and County of Swansea, who are the licence holder, would conspire with us to allow for more than 8 events. It is stretching reality beyond a legitimate point to candidly pretend that that is a real concern. I don't accept respectfully that that's a legitimate concern at all. Of course they wouldn't. And in any event, if they did, you would all have the perfectly legitimate power of licensing review, and the police and the council would have the perfectly legitimate power to make a closure order application. But the idea that the City and County are going to conspire with us to squeeze an extra event day out, it just, I'm sorry, but I just don't think the hearing is improved by our going back and through that. We don't accept that point at all.
Okay, thank you for that. Mr. Williams, you've got another question?
I have actually, yes.
Just a brief statement. The council previously applied for premises license.
Mr. Williams, if it's a question, ask a question.
Okay, I'll rephrase it as a question. Is everybody aware that the council previously applied for premises license to operate every weekend of the year? End of question.
I'm not, sir. No.
No, nobody's aware of that, Mr. Williams.
It did happen.
It
went to public meeting. Councillor Alan Lloyd was chairman. Take it up with him.
Yeah. Ms. Davis, you've got another question? Is it Ms. Davis?
Mrs. Peregrine Davis, I was corrected.
Yes, I have. That's okay. You mentioned, this is for Mr. Phillips, you mentioned about the hotline for complaints, should there be any. You also said, and I wrote it down, that you will have one person constantly on that line, and quite rightly logging everything. How can one person be enough? Because if you look in the bundle, you will see that several people have mentioned the fact that they simply cannot get through. One person is not enough. How can you solve that problem?
Our experience so far is that that has been a perfectly legitimate basis, we don't field dozens or hundreds of calls at our events. I can't say whether there has been a significant complaint profile for other events. We're going back over old ground. But our current assessment is that our having a dedicated resource to ensure that the phone is answered or the emails are replied to is entirely satisfactory. It is, of course, important to remember that the noise management plan needs to be signed off and agreed with the Environmental Protection Services. If they were of the view that that were insufficient, then we would have to develop it. But currently our view is that's perfectly proper.
Before I go back to Mr. Williams, it's now 1:15. I intend breaking out for lunch, and we only half hour because we lost an hour this morning, and back here at 1:45. Okay, thank you very much.
So do you
Good afternoon. I hope you're all fed and watered. So, who's here? Can you go to the end again? This was the new statement. Please. He's not here, is he?
No.
Say yes, I'm John.
Yes, I'm here.
Here.
Right, does the police want to make any statements or say anything at this point?
Yeah, yes, Mr. Chair, if I could just a brief summary from my point of view. As has been mentioned previously, the application has been dealt with on its merits, and a lot of that work went in following the debrief last year. So subsequently, we've come to a decision, therefore didn't need any extra conditions or representations here today. I would like to, if I may, just respond to a few points raised during the comments this morning. Firstly, in relation to something Mr. Edwards mentioned, whilst no, I do not wish to go into any sort of detail in terms of other events, the BBC event has been mentioned quite a few times, and I think it's only right to provide some facts in relation to that, as they've got no opportunity for any redress, especially so this is a public hearing. Just to confirm that during that event there were significant police resources inside and outside that event site, resources that were dedicated to the event, along with additional resources that were within the local communities to offer reassurance. So just to confirm, there were officers inside, there was no issues regarding access from that point of view. And also to confirm there was an event control room that was operational throughout the event, in line with all large-scale events that we attend, which contained representatives from all the emergency services and other partner agencies. So that information sharing is crucial to provide that safe event, and that was ongoing throughout the event. So hopefully that just clarifies a few points that was made earlier. Just in relation to comments in relation to last year's event, whilst I don't want to dispute Anne's personal experience that she had, I can confirm that there were arrests made at the event last year. That was a result of the nature of the event, any risk that posed, and whether there was a necessity to arrest. So there were arrests made at that event, and the learning out of that was taken on board, and which is why we've ended up with a detailed operating schedule today, which again the police have worked hard for the applicant, and that's it from me. Thank you.
Okay, thank you very much. Tom, have you got anything to add from the pollution side?
Only really just to sort of confirm what we do and what the team do on these sort of events. We pre-meet with the engineers, the consultants, looking at the noise maps and the forecast predictions. We have equipment at the nearest sensitive sort of receptor as per the condition, and the team then respond to complaints and go around the area with the sound level kit monitoring, looking for to ensure that we have compliance with the music noise level of 65 dBA. So it's just to clarify that point really, and we are out until the show ends, but we do respond to complaints, we do deal with complaints and go and listen and see what's going on and take the relevant readings.
Okay, thank you, Tom. Last now is the applicant.
If possible, Mr. Phipps, I'm just trying to raise a hand. Can you do it?
No, I can hear you. I can hear.
Thank you. During the lunch break, something came into my mind. Obviously, you provided dialogue in relation to the landlords or whichever departments of the local authority have confirmed they would be willing to forgo a day. Are you able to provide any documentation or anything just to confirm that? I know that I trust that you've said it, but of course it hasn't been placed within it before the the committee. I don't know, part of me thinks it should be relevant in the sense of just to confirm. If you disagree, fine.
I'm bound to say I disagree. I mean, if we just were to flip the conversation around, if I were acting for the residents, and of course I'm not, and it's silly to pretend I am, but if I were acting for the residents, producing documents at the conclusion of the hearing when we are already 2/3 of the way through closing speeches would be something that I would be very concerned about.
Yeah.
So that's point one. Point two is we have the confirmation. But candidly, if the committee were to conclude that my clients or I were so untrustworthy, just hear me out though. That they're so untrustworthy that I would say that when it wasn't true, then candidly, you're not going to grant us a license in any event, because why would you want us in Swansea? So I think that respectfully, the better answer is no. The other point to make, of course, is that in order to produce it, and it's only an email, I mean, let's not dress it up as more than it is, but in order to produce it, everybody would have to consent to its inclusion. So you only need one person to say, I don't want it included, which anybody would be perfectly within their rights to say. It's a bit of a cheek to produce something at 5 to 2 on a hearing that started at 10 o'clock. Then look, I understand the query, but the point, sorry, it's not quite answering the question you've asked, but the point of significance here is it's not about the production of the letter. It doesn't matter. It doesn't have any impact on the licensing objectives at all. We either produce the letter before the event or the event doesn't go ahead. So the worst that can happen would, I suspect, be gratefully received by the residents, if that makes sense. So there's no prejudice to anyone other than us.
There we are.
Yeah. Okay, fair enough. Mr. Phipps, it's on to you now to sum up.
So thanks.
If you wish.
Yes, unfortunately, it's a curse of being a solicitor. You can't help yourself, but just a couple of minutes. I'll do my best to keep it brief. But I haven't quite managed to find myself able to say to any committee yet, I don't need to sum up. So look, briefly, the obvious and fundamental points about this are that this is a good applicant, it's a good application, and actually it's a good event. And the paperwork, the documents, the experience of last year all tell you that. And when we're considering matters on a balance of probabilities, respectfully, there isn't anything that anybody can say that they've brought to bear that could possibly undermine that. But you don't have to take my word for it, really. You can look at the responsible authority engagement here. Police effectively say worked well with the applicants. We've made some advisories on improvements and those have been accepted. We engaged with the licensing authority before submitting the application and took account of some comments they made. And Environmental Health Services effectively say we've got a point of concern about the number. The solution that we've proposed is an absolute solution. Respectfully, particularly as I know that this might sound like I'm directing this towards your legal officer, I am struggling to understand the concern of our proposed condition. I would struggle to understand the concern if the 8 license was not held by the City and County of Swansea, because we have to get landlord's permission to occupy the space. We have to submit our documents before the Safety Advisory Group months in advance of the event. We have to invite them to site. They have to sign off on the documents. The materials have to be produced in further dialogue and discussion with officers who have perfectly good powers of closure and or licensing enforcement. But even if I park that, what we can't avoid knowing today is that this license is held by the City and County of Swansea. And so the idea that they would engage, or we candidly, and don't think me rude here, that you would engage in some sort of criminal conspiracy as if no one would notice that we were fixing up an event is so beyond the realms of reality that I'm candidly not sure that I'm really spending valuable time talking about it without putting it too bluntly. There is a hypothetical risk that the letter might not be produced. Let's say the letter isn't produced. how does that adversely impact the licensing objectives would be my challenge to anyone who are concerned by that, because it doesn't. It means the event can't go ahead. But if the event doesn't go ahead, the licensing objectives can't be undermined. And the only thing that we could and should be focused on today is the licensing objectives in a reasonable parameter of what might likely happen. That's what your policy and what the guidance specifically talks about. What is the likelihood of? What is appropriate? What's necessary? What's balanced? What's reasonable? Not some conceivable anxiety. And in those circumstances, and if you were to take, for example, shadow licenses, I know there's a concern about, well, it maybe has an interaction with another license. I don't say that that undermines the point about each application being on its individual merits. I don't accept that if that's a suggestion. What we've got to do is take account of the circumstances in which we find ourselves. And we perfectly legitimately do that, most obviously articulated by environmental health services, but also by a number of residents. A shadow license is an example where a landlord obtains a license to sit effectively behind an operating license to protect themselves against the operator potentially losing or surrendering their license. That's interdependent with the other license, but the one can't trade without the other. No one would suggest, and there are hundreds of those around, thousands probably around the country, no one would suggest that that was in any way not an application considered on its individual merits. So I'm spending all the time, if you will, talking about a point that I respectfully don't think is much of a point. The one point that I do accept, brought up by your legal advisor in the questions before lunch, is that, you know, it may be the committee's view that the wording could be improved. And if that's the view, then I accept that point. I'm not here to try and undermine the point. But if the committee were to prefer a different wording, then candidly, that's entirely within your gift and your discretion. But on the point of principle, I'm bound to say that everything about this case, the paperwork and the hearing, invites the conclusion that this is a fair and legitimate grant. And to just end in a slightly inflammatory way, but I'm not suggesting this. I would be saying that to you if we weren't offering the restrictive condition on 8. This is a good application for a good event that doesn't undermine the licensing objectives. But we are trying, although it feels like we're aggravating people with it, we are trying to accommodate the points that have been made with our solution. We are not wanting to cause aggravation to anyone, and we don't believe that our event will either. So in those circumstances, I invite you to grant it, albeit with the additional condition, either that we've proposed or with a slightly finessed wording as appropriate.
Right, thank you, Mr. Phipps. It's at this time now that we go into private session. So the public now will have to leave along with the licensing officer and along with the applicant. So that's all be left in the room will be councillors, our legal advisor and democratic services to make sure we say the right things. Thank you very much.
Thank you.
Can I thank